Hey everyone, this is Vaibhav and you're watching Logical Dreamer. So today we are going to learn some basic details regarding to ICA Indian Contract Act 1872. I believe that before learning any laws or about acts, we should grab a glance at the basic contents or details that are already provided in the bare acts, as it always helps in building a strong memory and easy to remember the data or any info. So let's begin. Date of enactment. Date of enactment means the day on which a bill becomes an act by the approval of governor. The date of enactment of ICA is 25th April 1872 and the date of commencement was the first day of September 1872. Date of commencement literally means coming into force. The day on which this act came into force. It was first day of September 1872, which made it extend to the whole territory of India. We already know that preamble is an introductory or expressionary part of any document, and this preamble of this specific act reads as whereas it is expedient to define and amend certain parts of the law relating to the contract. We can extract the objective and nature from its preamble that it clearly defines the certain parts of the law which have the relation with the contract. This act have the power to amend them too. So, if we talk about this act, originally there were 11 chapters and 266 sections, but chapter 7 and chapter 11 were repealed and formed into a different act. So, let's have a look on the chapters proposed under the Indian Contract Act 1872. So, the chapter 1 deals with the communication, acceptance, and revocation of proposals from section 3 to 9. As we all know that offer or proposal or acceptance or communication, these all play the vital role in the formation of an agreement or a contract. Without them, the contract or the agreement never exists. Chapter 2 deals with contracts, voidable contracts, and void agreements from section 10 to 30. Then contingent contracts are being defined under chapter 3 from section 31 to 36. These are the type of contracts in which a promise is conditional and some futuristic uncertain events are being introduced in these type of contracts. So chapter 4 literally defines the performance of the contracts from section 37 to 67. Chapter 5 certain relations or responsibility created by the contract, which means the rights or duties that has been created by the formation of contract between two parties. These are dealt under section 68 to 72. Then chapter 6 consequences of breach of contract. The terms and conditions which are not being followed by any party, they result in the breach of contract, and they are dealt under 70 section number 73 to 75. Already stated that chapter 7 was being repealed and formed into an act currently naming as Sale of Goods Act 1930, which was earlier dealt under ICA under section 75 to 123. Then the chapter 8, this is one of my favorite chapter because it deals with the contract of indemnity and contract of guarantee from section 124 to 147, and it's quite bit easier than any of the chapters. Then comes the chapter 9, bailment. Bailment actually refers to the term to the meaning delivery of goods from one person to another person. In this chapter we can learn about the persons like bailer and bailee and the lien and much more stuff regarding to this term from section 148 to 181. Then comes the chapter 10, This chapter is a bit longer than any of the chapter because it deals with the term agency, and it comprises of section 182 to 238. Then in this particular chapter we can learn about the relation between the principal and agent, the formation of agency, the termination of agency, and much more stuff regarding to this term. Then already stated, chapter 11 was also being repealed and was formed as an act, and today it is known as the Indian Partnership Act 1932. Earlier it was dealt under section 239 to 266. So guys, that's all for today about the act, and I hope it will be helpful for you all. So now I present you two legal maxims or terms with their meaning, and I also believe that this could help you to enhance your skills by implementation of these terms to your answers or argument. And I also promise that in every video I'll provide you at least two Latin legal maxims with their meaning. So let's start with the first one, ab initio. This legal term means from the beginning or from the initial stage. The AB term, ab term means from, and the initio one means initial or beginning. So it jointly spells as ab initio and means from the beginning or from the initial stage. Now the second one, act in pies, a judicial or other act performed out of the court and have no matter of record, which means any act that have no involvement of court or has been done privately, thus it doesn't have a record to maintain, and that's why it is called act in pies. It's basically used in French law. And that's all for today. Thank you for watching.